Okay, great. Welcome thanks very much, everybody. Thank you for coming and braving the winter cold on this Monday, nearly Christmas seminar. There's also people online. I'd like to welcome you as well. This is the seminar we've called The Immigration Revolution, All Change in Protection and Settlement Law. And I think that we are seeing obviously a significant change in the way that almost everything that we've ever done in our practices is now going to be done in the future. So it is quite an important moment, even though we are overburdened with lots of other work at this time of year in particular. So what we're going to cover today is all you need to know about the changes to the UK asylum policy and settlement policy that were set out in the Home Office statements of November 2025, a fairer pathway to settlement and restoring order and control. So we're going to be going through asylum rights with Maaha, Elahi on my right, and online with Zehrah, Hasan, and then Adrian, Berry, Casey and I are going to be dealing with the settlement and citizenship aspects. So we'll ask each person to speak for about 15 or so minutes, and then we could take questions at the end. So I think what I'm going to do is first of all formally and properly introduce Maaha Elahi. She's a barrister here, of course. Maaha has a broad civil practice, but she specialises in immigration, housing and public law. She particularly represents asylum seekers and deportees and other migrants at all levels in the tribunal, High Court and County Court. She does all judicial review and civil damages claims, both as junior counsel and in her own right. And she's been also acting in relation to prosecution of migrants in relation to those arriving by small boat. I don't mean she's acting for prosecution, but those who are subject to prosecutions. She does particularly also asylum claim certification, fresh claims and asylum support. So I'm going to hand over to Maaha. I think we're going to all speak from the lectern. And she's going to first of all deal with the changes of the first set of changes in asylum and protection rights. Thank you.
So yes, so I will be talking about the changes in protection law with Zehrah. So I will talk about these topics: arrivals reduction, asylum support, reduced appeals, Article 8 and Article 3.
As Sonali mentioned, the document that we're talking about today is Restoring Order and Control, and it was released in November. In terms of arrivals reduction, of course, that's a very big topic that's been in the media and quite politically charged more recently, especially in relation to the arrivals of migrants by small boat. The policy document addresses the pull factors that the Home Office would like to address in relation to protection rights, asylum support and illegal working. And they say these are the biggest pull factors for asylum seekers arriving in the UK. So I'll talk about asylum support a bit later, and Zehrah will talk about protection rights and illegal working. So arrivals reductions. There will be safe and legal routes with full security and controls. I think you'll hear me say many times in my presentation, what does that actually mean? Because it's very unclear, there's very little information. I'm sure you've all gathered that from what you already know so far. There will be new capped routes for refugees for whom this country will be the first safe country they encounter. There will be a focus on sponsorship, and that will become the framework that will involve voluntary and community sector organisations and in essence then sponsoring individuals who want to claim asylum here. There's a lot of talk about caps and restrictions. It will be based on the local capacity to support refugees. Arrival numbers will be controlled. There will be an annual cap on the number of arrivals, and a capped route for refugee and displaced people to work or study. In that policy document, there's quite a lot of mention of the routes for people from Hong Kong, Ukraine, Afghanistan, even Gaza for the study routes. But it's quite unclear what this means for
in terms of the immigration, the asylum system as we know now, and how this will impact, not of course the clients, but also our work. It doesn't seem to meaningfully open up the asylum system because, of course, there's this mention of refugee sponsorship. So that seems selective. It seems, obviously, there's very little information on what that actually means in practice and what that will look like. The Secretary of State has said that the routes will be modest at start in any event. So again, the meaningful change that it promises isn't quite clear. And of course, relying on refugee sponsorship ignores the many asylum claims that we all deal with, where it's more discrete issues, where there's not a generalised situation or an outbreak of conflict, but a discrete issue that an individual might face, for example, in terms of they face domestic or sexual abuse and are escaping that. So it's unclear how those individuals in those circumstances will be protected. Of course, it's capped and restrictive, and that there is an obligation under the Refugee Convention for states to cooperate in terms of providing international protection. So that again must be borne in mind when there's significant mention of capping this system. And the sponsorship, it's not state-led. It's not a part of the state system and the funding of international protection as we know it now. So it's very different to what we understand as our system now. There's no comment on what will change. Will it be, is there a goal for this to be the norm for asylum claims, or will the current situation of claiming asylum in country remain? It's very unclear. And of course, there has been much discussion over the last few years about the refugees claiming asylum in the first safe country of arrival. And of course, you all know very well, but there is no obligation under the Refugee Convention for them to actually do so. So that, again, is something that must be borne in mind when considering the safe and legal routes. Will this deter those seeking asylum? So, of course, this policy document is a reaction to the public and media discourse regarding the rise of asylum claims and asylum support. And so will this actually work? And I think that's something that's very important to be borne in mind. There's a lot of studies about this, and a recent one I read, which will be in the slides at the bottom, but by two academics, Waba and Diasio, looked into the most dominant determinants, I think from 2009 to 2020, of asylum seekers within the EU, and social networks was the most dominant factor, not economic or the welfare state or restrictions on the right to work. These weren't things that were the prominent motivating factors or the pull factors. It was social networks and an existing diaspora within these countries. I think another thing to be borne in mind, and we might have seen this in our own asylum claims for our clients, is that this could be the final chance for someone at gaining protection where they have passed through other countries within the EU and been refused, or they haven't received a decision and moved on. And so there's obviously a reason that people then continue to the UK. And of course, asylum seekers are escaping persecution. They may have limited knowledge of the policy developments, and of course, they themselves, like a great deal of all of our clients, don't have an education, so this information may not be readily available and digestible to them. Turning on to asylum support, again, another very hot topic. I think it's helpful to remember, or actually, of course, when you say you're an immigration lawyer, a lot of people always bring up all these discussions about asylum support, and I always tell people, did you know that they actually only get less than £10, of course, if they're accommodated and if they've been provided meals, and that's not very much. And when you consider other welfare benefits that obviously people with recourse to public funds get, that's very little. And this is a recent, this was in the news recently, and there was a recent report from the Home Affairs Committee that said that the expected cost of asylum accommodation has tripled from 4.5 billion to 15.3 billion. Of course, the factor within that report was the rise in the number of people arriving and claiming asylum. But there's quite a bit of emphasis on the neglect of the Home Office, on the day-to-day management of these contracts and the failure of the Home Office to recoup excess profits of millions of pounds. So again, that's something to be borne in mind in terms of this whole rhetoric around asylum support costing the taxpayer so much money, and that the asylum seekers are at fault or shouldn't be here, or that is what needs to be reformed. So what does the policy document on restoring order and control say about asylum support? It revokes the duty to provide asylum support, and it's going to be a move to a discretionary power. And so what that means in practice, again, is very unclear. It does seem like there would be judicial review challenges regarding, under Article 3, regarding the use of this discretionary power, which of course would make us all a lot more busier. And the report does say that asylum support will be denied or revoked from those who have the right to work here. Of course, noting that you can only request the right to work when you've been here for 12 months and you have some of the very limited skills that are listed for that guidance. Secondly, those who have deliberately made themselves destitute, what does that mean? I was scratching my head when I read that. I'm not quite sure how someone can deliberately make themselves destitute. Would that be absconding from the accommodation they've provided? I'm not quite sure. And anyone who has not complied with conditions, including removal directions or working illegally, were specifically mentioned. In terms of removal directions, again, we've all seen or been involved in JRs challenging the removal directions, upper tribunal claims challenging deportation orders. So what does that mean in terms of those challenges? Will that we then also have to include or also have to address the revocation of their asylum support? How quickly will that happen if they are challenging a removal direction? And that's something to be borne in mind. Compliance with UK law is also the other example mentioned in terms of denying or revoking asylum support. And firstly, what does that mean in terms of criminal offences, civil claims? It doesn't say what level of criminal offending would be involved. So would that be any conviction, any crime, any amount of time of imprisonment? Of course, it's important to bear in mind that those arriving via small boat in any event are possibly at risk of being prosecuted for their illegal arrival. Would that come under this and deny them the opportunity to have asylum support? And then, even more frustrating is within that same paragraph where compliance with UK law is addressed, the Home Office also mentioned those who refuse to locate to a different accommodation site and those who are disruptive in accommodation settings, as if that is a breach of UK law, which of course it's not. So in terms of relocation to a different accommodation site, of course, a lot of us have seen or worked on asylum support JRs relating to dispersal decisions. Again, what does that mean in practice in the future? Would that decision to remain and to seek to be in the same area or refuse accommodation because of the location, would that then mean that their asylum support would be denied or revoked? And disruptive in accommodation setting, what does that mean? Does that reach the criminal standard of harassment or something, or the civil standard of antisocial behaviour? It's very unclear. And how would reports of disruption be made? And it is quite concerning given that that's been mentioned under compliance with UK law. And in terms of contributions, this is something that has also received quite a significant amount of attention given the impact on asylum seekers if their belongings and their assets are taken away from them. So
they will be expected to contribute towards the cost of asylum support where they have some assets or income, but not enough to support themselves independently. And action will be taken if their assets later become convertible or they are discovered at a later date. And I mean, this has been reported quite a bit. The Home Office have said that this won't include family heirlooms or, for example, engagement rings or marriage rings or anything like that. But the impact of this would be quite significant on someone who has escaped persecution and come with very little to nothing. Also, it overlooks the fact that most people who do arrive and seek asylum do not have anything with them, and so the point of this is unclear. And I should also say there have been no proposals on the right to work, which seem to me as something that could address a lot of these issues in terms of asylum support. And lastly, the government have promised to end the use of hotels entirely by the end of this parliament and a move towards large sites, including military sites mentioned in the report for asylum accommodation. And this has been attempted before, for example, with the Napier barracks and Penally camp, where there was separately there was a High Court challenge, judicial review challenge in relation to that, which was successful. And again, reports by the ICIBI and HMIP on these on the living conditions. And of course, it goes without saying that a lot of asylum seekers, of course, suffer from mental health conditions, have experienced very traumatic situations, and to be in a military site could re-traumatize them, could impact their mental health. It would, of course, impact their integration because these military sites are not close to any towns. They're quite far out of the way, and it's not designed for long-term accommodation. And that's something that came up in both this case and in NB, and also in the report on Penally camp. And of course, it's almost de facto detention. They have bail, and they are then being placed in army barracks where there's likely to be security, and that, of course, would also impact them. Turning now to reduced appeals. So there have been a number of efforts addressing or trying to address the appeal backlog in the tribunal. There have been an increase in judicial sitting days, and the Border Security, Asylum and Immigration Bill, which recently received royal assent, brought in statutory timelines for appeals for those already in asylum accommodation or non-detained FNOs liable to deportation. And there's been a change from 24 weeks, or that the statutory timeline is 24 weeks, which of course seems unlikely given some of my clients have been waiting years, but that is what will come into force soon. And there will be an overhaul or an abolishment of the First Tier Tribunal. There will be professionally trained adjudicators to hear asylum appeals with safeguards to ensure high standards. I think that's something that's caused a lot of us concern, given that it's a very significant change in our asylum system as we know it. How it works in practice, again, I don't think anyone really knows. And in my view, there is no apparent problem with the tribunal system or the FTT. There is a backlog, but there are probably other ways of remedying that. The Lady Chief Justice recently said that the judiciary were given little or no notice of plans to abolish the First Tier Tribunal, and what it will mean in terms of how not only asylum seekers, but of course how we represent them, and whether there would be legal aid for that work is very unclear. There will be a single appeal route, and again, it's very unclear what that actually means. So the Lady Chief Justice did say that her understanding, and it was with a caveat of she might not be right and she's not sure what information is available, but she did say that she understood it as there would be a route from the decision by the trained adjudicators to the upper tribunal. But it is possible, I think, to read this document on restoring order and control
as suggesting that there wouldn't be a right to appeal to the upper tribunal, and that the only appeal right and decision you would get would be from the trained adjudicators. So it is very unclear what that means, again, not only for appeal rights, but also for our work. There will be early legal advice, unclear how early, and who it would be from, how that could be arranged. But of course, that's something that is promising. There will be decisions will be made to accelerate or expedite certain claims. That includes those with a low likelihood of success. And I think it's important to bear in mind the existing provisions for certification decisions where a claim is seen as clearly unfounded. And now another possible barrier where if your claim is deemed to have a low likelihood of success, the decision and the appeal will be accelerated and expedited. Also, there will be expedited appeals for first late time claims, for example, where someone is subject to a deportation order and has not previously made an asylum claim. And there will be legislation enacted to accelerate appeals for removable high harm cases, foreign national offenders and others detained and readily removable, and prioritising appeals in the public interest. So of course that will impact bail and in terms of obtaining bail when these cases are accelerated and they are likely to be removed very soon. Whether that is possible and will work in practice is another thing to be seen. And prioritising appeals in the public interest, again, is very unclear what that precisely means, what appeals would be in the public interest beyond the mention of high harm cases and foreign national offenders. I think it's important to bear in mind what exactly will we be told as their representatives. Will we be told if a decision is accelerated or expedited? Will we have a chance to respond to that, to challenge that decision? How will these decisions be made? And I think, of course, there are Article 6 concerns in relation to this. We've all seen or dealt with asylum appeals where more information comes about when you're preparing the appeal bundle. And that significantly can, of course, strengthen the asylum claim, and to subject asylum seekers in this situation to expedition seems like it could infringe upon their Article 6 rights, which require them to have a fair hearing within a reasonable time. And the policy document also mentions strengthening the approach to dealing with protection and human rights claims clearly without merit. So it seems to be something to do with strengthening certification decisions, but what that means in practice is very unclear. Asylum seekers will be expected to leave if refused, and otherwise return will be enforced. Again, unclear how that is different to the current position. There will be, and I will touch upon Article 8 in more detail a bit later, but there will be legislation enacted to ensure that if a person does not leave, any private or family life accrued after will not override the public interest unless in the most exceptional cases. And that is, of course, quite concerning. For example, in situations where they do have a child or enter into a relationship after that. And there will be financial packages, including the trialling of increased incentive payments. Also concerning, given there is a voluntary return scheme that exists, a great deal of these reforms seem to be in relation to taxpayers' money, and so an increased incentive payment does not seem to be an appropriate response. And further submissions. So you will still be able to make further submissions. The appeals body, i.e. the adjudicators, will consider those further submissions, but you will be required to demonstrate why the matter is being raised late and that it is substantially different from the initial claim. Of course, the existing test under the immigration rules is significantly different. So if there will be a change in the test, that remains to be seen.
where an individual doesn't engage or provide evidence, their claim will be treated as withdrawn. And failed asylum seekers will only be able to apply and make a human rights claim if they pay the relevant fee. Now turning to Article 8, the reasons for strengthening the public interest test are contained there. It's not clear how this is different from Section 117B to C of the 2002 Act, and how this will go beyond and then change the nature of the test. And there will be legislation enacted to narrow the circumstances in which Article 8 rights outweigh the public interest. Again, much remains to be seen. What we do know is that family life will not go beyond immediate family members unless in exceptional circumstances. There will be a definition of family life contained within the legislation. And as a reminder, of course, it seems quite obvious that refugees need a more favourable family reunion policy, given that they have escaped persecution and they cannot return to their home country. Entry clearance, it seems that entry clearance applications under Article 8 can continue, but in-country applications will have to be subject to the relevant fee, and will prescribe how and when Article 8 claims can be made, or to prevent frustrating removals and the avoidance of fees. And Article 3, there's not much information on Article 3 and how that will change. There's just mentioned that the interpretation of Article 3 has been expanded over time, and it has meant that those who have committed serious offences can stay here, and deportations are blocked because of their healthcare needs. Of course, we all know how high that threshold is, particularly, for example, for healthcare under AM Zimbabwe. And it seems that this is very preliminary, and they are working to define inhumane and degrading treatment. And so that opens up the scope for possible challenges in relation to the interpretation of Article 3 and 8 in line with existing case law, the Human Rights Act, and case law from Strasbourg as well. So that's a whistle-stop tour of those changes. Thank you for listening to what was effectively me ranting about these changes. If you have any questions, I'd be happy to answer them. Thank you.
I think what I'm going to do is move on to the next speaker and then take questions at the end. So I'd like to thank you very much, Maaha. I'd like to introduce our next speaker online. That's Zehrah Hasan, barrister at Garden Court. Of course, she practices in immigration, asylum and public law, and she has a history of working with Rainbow Migration's legal team as a consultant lawyer. She's also worked in several leading NGOs, including Advocacy Director of JTWI and in policy and campaigning roles at Liberty and Southall Black Sisters. So I'd like to ask Zehrah to speak to her presentation, which is From Refuge to Removal. Thank you.
Thank you, Sonali, and thank you so much, Maaha, as well. Good evening, everyone, and apologies not to be with you in person, but thank you to marketing for facilitating this hybrid event. And I can see that we also have about 80 people online, so welcome to everyone who's joined us this evening. I will be covering the government's proposed changes to protection rights, workers' rights, and subsequent plans to increase returns and removals. There's quite a lot to cover, so I'll also be doing a bit of a whistle-stop tour, and outlining some of the key proposals and the concerns that I see arise from them. Next slide, please. So I think it's really important that we ground what the government is trying to do with these proposals in a much wider political and global context. And in its paper, the government says one of the key reasons for these changes is, quote, increased conflict leading to a significant increase in the movement of people across the globe. I think what's really striking about this is, of course, Britain's role in this landscape, and in this role of conflict worldwide, in terms of wars internationally, its role in the arms trade and climate degradation. And I always come back to this quote from Sivanandan, who's a very prominent anti-racist activist, who talks about the fact that we are here because you were there. So ultimately linking migration patterns in the UK to Britain's colonial past and also its military and corporate interests abroad in the present. Another very striking aspect about these proposals is it continues to fuel this sort of false dichotomy between so-called genuine refugees and economic migrants, which we've seen in the media and in the sort of political establishment being used to sow division across and between communities. And the government in these proposals goes as far to say, another quote, even amongst those who are genuine refugees, economic incentives are at play. And they talk about so-called asylum shopping, even though, as Maaha mentioned, there's no requirement under the Refugee Convention to claim asylum in the first safe country. There's also no acknowledgement, of course, of the sort of wider global context that Britain is situated in when it comes to refugee protection. The majority of refugees seek protection in the global south. We know, for instance, that over a third of the world's refugees and people in need of international protection are hosted in other countries, including Colombia, Turkey, Iran, and Uganda. 66% of people are hosted in neighboring countries. And when it comes to Europe, the Refugee Council's most recent statistics show that ultimately the UK ranks 15th in Europe in terms of the number of asylum applications per head of population. So it's below average amongst European countries. The top 5 countries of people seeking asylum in the UK are listed on the slide. So Pakistan, Eritrea, Iran, Afghanistan, and Bangladesh. So again, countries with colonial links to Britain or that have been historically affected by UK-driven resource extraction and conflict. And then from that small number of the global refugee population who do come to the UK and claim asylum, we see around half are granted protection in initial decisions. And in 2024, 43% of appeals were allowed. So less than 1% of the UK's population are refugees or people seeking asylum. And that's in a context where the UK is obviously also one of the richest countries in the world. And so I frame it in this context because I think it's important to remember that the government would have us believe that these changes are necessary because there are problems in terms of resource scarcity. But ultimately, in my view, this is a question of resource distribution. And the government's using this to sort of say, well, this increase in the number of people claiming asylum justifies their need to ramp up removals and to ramp up immigration enforcement and to overhaul the UK's asylum immigration and immigration system in this very dramatic way. But ultimately, it's scapegoating around 100,000 people who claimed asylum in the last year for economic failings of this and previous governments, and it's watering down significant and fundamental safeguards in doing so. Next slide, please. So the first aspect of this very significant shift that I'm going to talk about are protection rights and the shift to temporary protection status. So as most of you will know who practice in this area, the current position is that people who are granted protection status are granted that for 5 years, and then they can apply for settlement, so indefinite leave to remain. And also there was, of course, the right to family reunion. Now, what the government's trying to do in this proposal is reflect the model of Denmark, where refugee status is temporary and lasts only until a refugee can safely return home. In Denmark, the model is that someone will be granted leave to remain for 2 years, so temporary residence, and there will be significant requirements on them sponsoring family members. It's only after 8 years residence that they can apply for settlement, and that comes with conditions of full-time employment, meeting an earnings threshold, language proficiency, and what they call active citizenship. And I've just included a quote on the slide from a Syrian refugee who's subject to Denmark's temporary system, who said, "You rebuild everything while knowing it can be taken away at any moment." Now, what's concerning is in trying to reflect the Denmark model, the UK's proposals are even more restrictive. And they're premised ultimately on this idea of what the UK government is calling core protection. So what they see as the bare minimum of complying with international obligations. It's questionable whether they do in any event. So under those proposals, this core protection would look like refugees receiving 30 months of leave to remain. So it would be reviewed every 2.5 years. And putting this into context, the Refugee Council has estimated that if this policy were enforced now, that would mean reviewing the status of 1.4 million people between now and 2035. So obviously, that will only add to what we already know is a huge amount of Home Office decision-making and associated legal challenges that come with that, and of course, the associated cost of the system. So in these 2.5-year reviews, someone's protection status will only be renewed if they are considered still in need of protection. And where the Home Office considers they are no longer in need, that person will become liable for removal from the UK. There will also be no path to indefinite settled status in the UK on the core protection route until a refugee has spent 20 years in the country, which is a significant shift, and there would be no right to family reunion. What the government goes on to say in these proposals is they will try to encourage refugees to switch out of this core protection route into another route, another in-country route called the protection, work and study visa. And that would be available if they obtain employment or commence study at an appropriate level, and there would be a fee associated with that. And what they are suggesting is that once someone's on this route, they would be able to earn settlement sooner than they would under the core protection route, which was 20 years. But none of it is clear, as Maaha sort of indicated. None of these proposals are clear as to how they would do that. And I think Sonali and Adrian are also going to address the problems with this sort of earned settlement framework. Also, we know that for people with insecure status, it's much harder to find employment, to access housing and education. And of course, none of this factors in the significant issues we all know clients face when they face persecution. For example, extreme trauma, experiences of trafficking, torture, domestic violence. They may have physical or mental health difficulties. We know refugees are 10 times more likely to develop PTSD. So again, all of this will also hamper their ability to find work or access education to switch onto this route. For those on the protection, work and study route, they will be able to apply for family sponsorship. So they will be able to do that, but the same conditions will apply for other migrants and UK citizens. So it's going to be much more restrictive than what we've known so far. Next slide, please. So the starting point, I think, is what does the Refugee Convention say and how can we understand temporary protection with regards to our international obligations? Well, the fundamental principle of surrogate protection under the Refugee Convention is that people whose country of origin is unable or unwilling to provide that protection itself access this international protection regime. And that must be effective and accessible. And I think it's important to sort of ground this in looking at what Lord Roger said in the case of Asfor, where he spoke about the spirit behind the convention is treating refugees humanely, people having a recognized place in the world, and not as beings who can exist only at the margins. There has to be a measure of dignity. And of course, we know the Refugee Convention also guarantees socioeconomic rights to refugees. So the principles of non-discrimination, rights to gainful employment, welfare, labour rights, and assimilation. So really, this temporary protection status will be pushing refugees into the very margins that are contrary to the spirit and the letter of the convention itself. And what has the UNHCR said about temporary protection? Well, the UNHCR has said that temporary protection should not be used to discourage or prevent people from seeking asylum. And it's not a protection scheme that should replace existing international obligations, in particular under the 1951 Convention. But despite this, the Labour government's proposals are using the temporary protection scheme as a so-called deterrent policy, because the Home Secretary has described the current rules regarding refugee resettlement as a pull factor. It's also concerning because this is not actually grounded in reality or research. Oxford University's Migration Observatory noted that people seeking asylum rarely know the details of a destination's migration policies. And most people come to the UK because, for instance, they speak English or they have family or community ties here. And again, that links back to the colonial links between Britain and other countries in the world. The UNHCR also talks more about temporary protection in the context of emergency provision. And in response to these particular proposals, it has said that short-term stay arrangements and stringent limitations on refugee family reunion often create prolonged uncertainty and despair, undermining integration and social cohesion. So there's widespread concern, I think, about how this really looks in practice, and whether this is going to be compliant with our international obligations. I'd also just note at this point that in enforcing a sort of temporary protection regime, the government is likely to have some kind of blanket designations as to what are safe conditions in countries where they think that people can return to. And we know already from looking at how inadmissibility and certification decisions are made, that these blanket designations often fail to reflect the realities that are faced by specific groups of people. So, for example, LGBTQI plus people seeking asylum might face particular problems in a country that the Home Office considers safe. Georgia is a really good example of this. The government has recently legislated to designate Georgia as a safe country, but that's despite oppressive laws and violence against LGBT people there. And there's, of course, the risk of people being re-traumatized by having to discuss their experiences of persecution over and over again for each renewal. So people are not being given a sort of meaningful opportunity to move past those experiences of persecution and move on with their lives. Next slide, please. So I'm going to move on now to workers' rights and increased enforcement and digital borders. So many of you, of course, will be familiar with the current situation where people seeking asylum are not allowed to work unless they have 3C leave or unless they apply for permission because they've been waiting for an initial decision for more than 12 months. We also know the problems with the immigration salary list and how restrictive that is for people seeking asylum who might be granted the right to work. And this is out of step already with other EU countries. In most EU countries, people can work after 9 months. In Germany, it's 3 months. In Italy and Greece, it's 2 months. And campaigners have long been calling for this ban to be lifted. I'd sort of reference in particular the Lift the Ban coalition run by Refugee Action. What the government has proposed to do is to expand right to work checks and the digital hostile environment, and it's silent, notably, on lifting the ban on asylum seekers being able to work. A lot of this reflects what is in the Border Security, Asylum and Immigration Act, which received royal assent earlier this month. But what the government has made clear is it's planning to target the gig economy. So particularly it talks about working with online delivery companies regarding right to work checks and ID verification across platforms and data sharing agreements to identify people who are seeking asylum, who are working, for instance, as delivery drivers. This is all extremely concerning because it's essentially an expansion of the hostile environment. It's another attempt to bring in immigration enforcement into everyday life. And it's replete with issues that we've already seen. For instance, with employer checks, we know that those can be extremely fallible and subject to errors as a result of the technology itself. We know that, for instance, digital ID verification is tainted by racial bias often. There was a case in 2024 where an Uber Eats driver had his case settled because he claimed that AI facial recognition checks were racially discriminatory under the Equality Act. And we also know that there have been errors in the kind of administrative processing of those checks. So where they're ultimately just wrong, someone does have the right to work, it comes up that they don't, and then they face, for instance, unfair dismissal or discrimination in the workplace. And there are inevitably privacy concerns as well when it comes to third parties handling personal data. Now, the government also particularly names people in low-paid jobs, such as in the hospitality, construction, delivery, and other sectors. But we know that in these sectors, people who do not have the right to work but are in those sectors are at increased risk of exploitation. And there's a British Red Cross and UNHCR report, which I've included on the slide, which found that people seeking asylum in the UK are at risk of exploitation, particularly with regards to domestic servitude, sexual and labour exploitation, and forced criminality. So what we're seeing with these proposals is, again, a kind of prioritisation of enforcement and not safety. And this is in a context where, as Maaha referenced, people are already being pushed into precarity and poverty by the low asylum support rates. And in the sort of current crisis, the cost of living crisis, it's clear why people are then driven into positions where they have to support themselves, and then they are punished for doing so. Next slide, please. So I've set out on the slide here some of the kind of existing issues with the sort of regime for workers' rights and migrant justice. And I'd particularly encourage people to have a look at JSWI's Work It Out campaign, which sets out some clear policy demands. But unfortunately, we're seeing a complete slide back away from any kind of progressive or positive change and actually into a system that's going to be even more hostile and oppressive. We know that the Labour government has had a particular focus on increasing immigration enforcement. It has increased raids on workplaces. It said that that increase has been a 63% increase. And we know that it's increased removals as a result of those raids. Immigration raids are, of course, a deeply concerning part of the hostile environment. There's a Migrants' Rights Network report that focuses particularly on how raids target racialized communities and areas with highly racialized populations. They heighten fear, insecurity, social isolation and exclusion. And of course, we're seeing, on the other side in the US, how ICE raids in an increasingly hostile environment there have torn families apart and been deeply oppressive. So it is extremely concerning that this government appears to be prioritizing those forms of quite violent enforcement over trying to consider the risks of exploitation that people face when they are pushed into precarious work. Next slide, please. So the next point that I will whiz through are the issues with returns. So again, these proposals have set out quite a few ways that they plan to increase the ability to return people to their country of origin. And one way that they're planning to do this is by enforcing Section 72 of the Nationality and Borders Act, which I've set out on the slide. But this essentially relates to visa penalties for countries that they say are not cooperating in returns of their nationals. Next slide, please. So under these provisions, what could happen is that the UK government could suspend granting entry clearance for nationals of a country until it takes back citizens who are in the UK. So these are effectively sanctions on countries. They are essentially setting out that in the recent year, they've had agreements with countries like Iraq and Vietnam to streamline returns processes, but they've said that some countries are delaying and not cooperating on returns. And in the media, they have particularly targeted countries like Angola, the DRC, and Namibia. Now, obviously, there are huge concerns about sort of visa penalties on countries based on returns. What will happen, for instance, to people who want to claim protection and there's then no safe route available for them because there are sanctions in place? It will inevitably then drive more people into being forced to take dangerous journeys. And also, this is a highly politicized way of trying to reach agreements with other countries. It could target countries for sort of other reasons, or it might just be a performative aspect of this government's policy where it's seeking to sort of look tough on an issue when actually this won't be workable in practice. They also have reavowed their commitment to the UK-France scheme, which, of course, lots of people here, I'm sure, will have been working on or seen in the media what's been happening with that system. They want to expand that scheme despite the known problems that have happened during the pilot. And this is, of course, in the context of a lack of safe routes for people crossing the Channel. People who have been returned to France under the existing treaty have reported living in fear of return to their country of origin and living in extremely poor conditions, including homelessness. And we know that one person actually came back to the UK after being removed to France because of his fear of modern slavery there. Also, the very premise of that policy is that for each person removed back to France, the policy brings someone from France to the UK on a safe route. So even by the government's own logic, that doesn't do anything in terms of decreasing the numbers, and nor will it stop, as we've seen, people being forced into dangerous journeys across the Channel. And then the third point on returns is the government's spoken about having return hubs, so safe third country agreements with places where they would send people to, so essentially offshore people to, in order to process returns to their country of origin. Now, the proposals around this are very vague at present, but they do appear to somewhat reflect what's been happening in the European Commission, where similar proposals have been made for there to be detention facilities located outside of the EU's borders to hold people whose asylum applications have been refused, and where they would then be returned to their country of origin. So, for instance, Italy has a scheme like this with Albania. Now, NGOs have warned very clearly that these facilities will, of course, result in people being uprooted from their communities, families will be torn apart, but also people will be held in, prison-like poor conditions and at grave risk of increased human rights violations. To implement this, the UK would need to sign bilateral agreements with third countries, and they would need to define the conditions for someone being transferred there. But in October this year, Kosovo said that it was to become the first country to sort of enter discussions with the UK around such plans. And the BBC has reported that these proposals are going to be focused on countries in the Western Balkans. Of course, there's the inevitable cruelty that sending someone to a country to be held indefinitely where they have no connection there. They risk facing degrading conditions and treatment, as well as fear of return to their country of origin. And, you know, there are concerns in the wider context of sort of speeding up decisions, and removals will mean people who did have claims in the UK to make are ultimately then offshored onto this sort of returns scheme without the ability to pursue those claims. Next slide, please. And the last topic to cover is the increase in removals that will come with all of this. This entire scheme is essentially set up to increase removals. So, for instance, even the temporary protection scheme, if someone's status is not renewed, or they fall out of status, or they become undocumented as a result, or their claims are sped through, appeal decisions are sped through, then all of this is going to lead to more removals. The government's also planned to increase removals by increasing the refusal of protection claims after a single interview, so potentially at the screening stage, for people from so-called safe countries. It's not clear if this is going to be an expansion of the existing inadmissibility rules. We know that the government already has powers to do this, but that's something that they have specifically mentioned in the proposals. There's also a kind of striking reference to the government seeing age assessments as a barrier to removal, which is of course extremely concerning. Regardless of whether someone's a child or an adult, their claim has to be properly considered regardless of age. But the government's proposals include plans to introduce AI age assessments, but particularly facial age estimation technology. This technology, there are obvious problems with this, but there are well-documented concerns about racial bias in that technology, and of course how invasive and traumatizing it would be. And the government's also talked about resuming removals to certain countries. So they have specifically highlighted Syria. So they've talked about where there's been regime change, that their approach to refugee protection should change too. And we've already kind of seen this happening anecdotally through the back door, where Syrian refugees who've applied for indefinite leave to remain are now receiving letters from the Home Office saying their status is being reviewed. So this is something that's sort of already starting to happen, it seems, and there are concerns that it will happen in different country contexts as well. There's also going to be an imminent consultation on enforced removals of families with children, and that would be to commence measures in the Immigration Act 2016 to remove support from families who do not have what the government's saying is an obstacle to leaving the UK. Again, if that's not taken up voluntarily, they're going to enforce those returns. So this is inevitably going to legitimize the detention and removal of children who've spent their childhood in the UK and families who've set down roots and become parts of our communities. And of course, with increased removals will come increased detentions and all the associated trauma, abuses, and distress that we know already occurs in the detention regime. So ultimately, as Maaha sort of indicated, we are going to see more cases. We're going to see, with this whole sort of overhaul of the system, more people in need of legal representation. And this is in a context where there's already a crisis with legal aid, and no set for the government, no sort of store for the government to address that. And for our clients, people seeking asylum will be in limbo, uncertainty, and precarity for a lot longer. And I think, unfortunately, this comes in a context where the government has been focused on political point scoring over what could actually be an effective and just system for people seeking protection in this country. So that is sort of, yes, whistle-stop tour of those issues, but happy to answer any questions at the end as well.
Great, thank you so much, Sarah. That was really excellent presentation and detail, giving us all the detail. In the interest of time, I'm just going to introduce myself by moving over here. I'm Sonali, Naik, one of the Joint Heads of Chambers, Immigration and Public Law Practitioner. I realise that I'm standing here, which is now obscuring your view of the slides. So I hope we'll be able to manage that. So I'm just going to particularly talk now about the earned settlement provisions, and then Adrian is going to talk about the citizenship proposals. And so, of course, Maaha and Zehrah have touched on those by foreshadowing who is going to be affected and what are the proposals. And importantly, oh, am I going the wrong way? Right, here we are. So, the key change in the government's document is that settlement is to be a privilege that is earned through contribution, and the baseline qualifying period is going to rise from 5 to 10 years. And also the qualifying period will vary by route and by individual applicant. And then we'll come to see what are the differences between settlement and citizenship going forwards. So we've already heard a lot about the government saying that in their own view over the years that settlement is a privilege, but now they're formalising what that privilege is and how it is going to be earned. So, as we know, the current provisions ordinarily require settlement after 5 years residence, and that once you have settlement, there's no time limit, you can work, you can study, you can access public funds, and of course, it's a prerequisite for British citizenship, and it's only ordinarily revocable for criminality, deception, or long absence. And the rationale for the reform is that, of course, the rising projected settlement numbers, which are actually a consequence of the previous government's immigration policy. So the forecast in the 2026-2030 period is up to 1.6 million people. Now, importantly, a lot of those people, or a significant number, are health and care and skilled worker routes, people who the previous governments have decided should be granted visas to come to the UK. So they are lawful migrants who, through government policy, were either invited or permitted to come and to work in the UK. And that is, you might think, is pulling the rug out from under people's feet. And we've had some historical litigation on points like this in the past. The rationale was about concerns about fiscal impact, which is interesting because, of course, those people do all work and pay tax, and integration. And so we'll come to look at what that's going to look like. This is just a graph. It's from the paper about the projected number of settlement applications in the next, how they have been and how they are projected to go forwards up to 2030. And the numbers on the left are in the 100,000. So 630,000, I think, was the figure that's projected in 2028. But then it is also projected to decrease, but they will say that's on the basis of their proposals. But that is the current figure. So who is going to be affected? Everyone applying for settlement, except those under the EUSS scheme. And there's two separate points to note. That first of all, there are new mandatory settlement requirements which seem to apply to everyone applying for settlement, not those aren't subject to consultation, and we'll talk about those in a moment. And second, the changes to periods that people must wait before they can apply for settlement, and that is the focus of the consultation. So, and importantly, and this is something that I think Zehrah just touched on about transitional provisions, there's every indication that these proposals will apply to people who are already here, and we specifically know that care workers is a target. There is potential for there to be transitional provisions for some groups and not for all groups. But importantly, what's said in the government's proposal is that people who are already here with settlement won't be affected. That's what the Shabana Mahmood introduction to the paper says. That's just not what we just heard from Zehrah in terms of people who are settled refugees. So we do need to be really careful about that. And those who've got long enough memories will remember the highly skilled migrants test case, I think is 2009. People who brought successfully challenged the change to the settlement provisions for that group of people who migrated, encouraged to migrate, and on the route to settlement, and then told that that wasn't going to be available to them, and ultimately that provision was changed. So we need to think about importantly, was Shabana Mahmood put in her document that it wasn't fair those were her words, it's not fair to take away settlement from people who are already here. So then if fairness is a relevant consideration, are these proposals legally fair? Whatever people might think about political fairness, there is obviously what we're talking about, legal concept of fairness. Just going to Appendix FM, obviously the 5-year route, people are largely unaffected, but query family members of British citizens only. That's how it looks from my understanding. But the 10-year route, people on the 10-year route, hugely likely to be affected because they are the people who can't meet the requirements of the immigration rules because of immigration status or financial requirements. So, and those applying to, those who were intending to apply under long residence, it looks like that route will go. And it's in any event, for people who accrue certain periods of residence, for example, students and graduates, they don't look like they're in a category that's going to lead to settlement in any event. So importantly, just so I'm whizzing through because I want to make sure we get to the end of my presentation to Adrian's, the target is skilled workers. The earned settlement proposals target this group and their dependents, and the government have made it clear that they are the lower earners of those who will be penalised. That's what's on the extract there from X, even though they say we're going to high earners, entrepreneurs and skilled frontline workers like NHS staff will be fast-tracked to settlement, but actually obviously some of those people who work within the NHS are not going to be high earners. There are vulnerable groups, so the consultation asks if certain groups should be excluded from the proposals. Bereaved partners, survivors of domestic violence and abuse, those people who are currently in that long fought for what was originally a concession and then imported into the immigration rules. So we would hope that some of those concessions and then rules will survive. Adults with long-term care needs, and children and young adults who grew up in the UK without immigration status, although excluding care leavers and children in care. So there are quite a few groups who fit within that category. So when we come to the end, and I will encourage people to fill in the consultation, talk about that in a moment, but that's what the government are consulting on. But the proposals in relation to earned settlement have this sort of 4 pillars model, and they use that phrase. Character, so mandatory suitability checks, criminality thresholds are being tightened, integration, so requiring an increased level of English and life in the UK test, contribution, which is economic activity, earnings and community involvement, have a look at those, and residence, as in lawful continuous residence. So those are the 4 key considerations for people who are seeking to earn their settlement. The mandatory requirements, so these are that you have a clean criminal record, no outstanding government debt, the English level at B2 and the life in the UK test, and also that your earnings are above that level, 12,570 for 3 to 5 years. Then there are ways of reducing the qualifying period. So this is that going back to that little X slide that we looked at a moment ago. Higher earnings. If you have, if you're earning £50,000, then you may be able to reduce your qualifying period by up to 5 years. If you have a particularly high earnings, 125,000 plus, you can maybe reduce the qualifying period by up to 7 years. If you have, again, public service roles, you can reduce the qualifying period by up to 5 years. And volunteering and community contributions, you can see there, reducing the qualifying period from between 3 to 5 years. And if you have a higher level of English, reducing reduced by 1 year. So this is I keep forgetting this phrase because it's so peculiar. It's called the time adjustment model. I never heard it before, but there it is. That's what is behind this government proposal in terms of the way in which the operation of the settlement provisions will work. So as you can see on this next slide, that the increased use of the qualifying period, if you have those factors that will increase that qualifying period are the use of public funds. So for less than 12 months, it might increase by 5 years. Use of public funds for more than 12 months, 10 years. And if you are somebody who's an illegal entrant or visitor who's overstayed, up to 20 years. So it might take you 30 years to get your settlement. And I think in 2012, when they changed the immigration rules then, I think I wrote a paper called The Long Road to Settlement. Well, it's just like I can't even think it's like a marathon. It's a really long road to trying to integrate yourself into the UK when you may have been using public funds for obvious reasons that are certainly beyond your control or health, for example. And then the lower skilled work routes, potentially a baseline of 15 years. On benefits, there is still a consultation on the question of no recourse to public funds. I don't know if Adrian might be speaking about this, because obviously at the moment you can have recourse at the point of settlement, but this is a proposed change. It wouldn't apply, as they say, to existing settled persons, and it would require a change to primary legislation. And then looking at the suggestion is that family members and British citizens, family members of settled persons and British citizens will be treated differently. The impact on existing routes, so most 5-year routes have moved to 10-year routes unless you get this reduction earned or get further penalty, so either way. The long residence route, which we currently have, has been subsumed into this earned settlement structure, and then you still have the highly skilled route of the innovator or global talent who will retain the accelerated 3-year path. Dependents have to be assessed independently. Children can be granted settlement with their parents within an age window. You include children who otherwise would age out, but the focus in the paper is that the grant of ILR will be dependent on the main applicant. So that's the general focus. And there were these few safeguards for young people who were unaware of their unlawful status. So back to the point I raised earlier about vulnerable groups, potentially. This is the part for consultation, domestic violence victims, bereaved partners, resettled refugees. So importantly, they say, if you're a refugee, that doesn't make you vulnerable, according to this paper. If you're a resettled refugee, they were looking at questions about consultation in relation to whether you should have different provisions in relation to earned settlement. And then they have indicated tailored pathways retained on compassionate grounds. So obviously what this means is of great concern, and that touches on what Zehrah said in her presentation, which is applying an economic lens to refugees and family members, which is not how it's been done historically, should we say. Changing the rules after entry is that unfair? As I said, legally unfair, which breach of legitimate expectation, as we had in HSMP. Tying visas being tied to your visa for 10 years potentially is a recipe or certainly an indicator potentially for exploitation, and then having differing status for main and family migrants. So as a whole, the scheme isn't promoting integration, certainly not for all migrants. It's certain people, only really the highly skilled global talent people are going to be fast-tracked for integration. Otherwise, the aim of the scheme is to reduce the number of people who will qualify for settlement or defer the length of time and the period when they can acquire it. So that is the express aim of the scheme. And so would recommend that people who are here in this room who have expertise and experience and case studies, most importantly, to respond to the consultation. And those are the deadlines. It closes very soon, and we want you to take it across Christmas. It's 12th of February, and there will be a statement of changes in the spring. And so what we see from that, I think, is that realistically, it's probably all been written already, may not have been, I'm not a cynic, but whatever happens, it's going to be implemented in the spring. That's spring could be a slightly movable feast, but let's say March. And if the closing of the consultation is in mid-February, then we need to get a move on and try to make sure that the consultation is meaningful, and that if we can identify areas of potential unfairness or the breach of legitimate expectation, then we can respond to that appropriately and in the context of either looking at challenges in relation to discretion or human rights framework. That's where we need to take these forward. We've done it before. The environment is, the external environment, no doubt, is particularly changed, but I do think there will be inevitably litigation. I would call it an opportunity, but I don't regard it as something positive. But litigation, I'll say that. Thank you. Now, thank you very much. Hand over to Adrian Berry-Casey. He probably doesn't need too much introduction either, so I'm going to leave that so that he can speak to you, and we'll have time for a few questions. Thank you, Adrian.
Thank you. I'm sorry about standing in front of the slides. Very unfortunate thing is I spent the morning writing them, but I hope you can see them. What I want to talk to you, in fact, there's the next slide. Moving on.
So you want
do I need
the clicker?
There we are. Sorry, I can't do anything. Can I?
Down.
There we go. So a nice uncontroversial title for my talk. But what I want to do is to really take apart the idea that this is contributing to anything, and to show you in detail from a legal perspective as well why it doesn't work. And what we have in the Earned Citizenship and Earned Settlement paper is an attempt to devise a policy for feelings. And the problem with that, as we'll see, is that along the way, you actually manufacture a situation where you have a separate legal regime for people in terms of their working lives in this country. Because as Sonali indicated, what we have is a policy in the Earned Settlement and Citizenship paper, or a fairer pathway to settlement, that deals with lawfully resident people and their lives, and the lives that they have been encouraged to live here. And the issue, as you'll see there, is there is a certain justification for this policy, but all the way, as we see along the way, every little thing that happens to the person who's lawfully resident is about putting a barrier into their integration, and for individuals and communities to their integration into UK society. Firstly, by lengthening the process, secondly, by imposing a series of higher and higher hurdles, and thirdly, ultimately, for creating a lived experience where we understand, both from the settled population and from those who are subject to immigration control, that some people are different and will live differently. They will live in different accommodation. They will be employed potentially by different people. And this has an impact from the perspective of equality, of access to legal remedies. It has an impact on access to employment rights and so on. And I'll show you how and why, if you were to devise a policy designed to divide people one from each other, you'd be hard pushed to come up with a better model than we see in the fairer pathway to settlement. And so I'm going to show you practically how this works. And say, what worries the Home Secretary, and she goes into some length in the introduction to her paper, is that somehow patriotism is being divided from those who have a broader perspective on it to a more narrower nativist perspective. And she asks rhetorically, without answering the question, what's the cause of this division and how might we become united? Well, manufacturing segregation is not the way to achieve that. But you'll see there that people have been lawfully encouraged to come in significant numbers, that policymakers in the Home Office are shocked that they might be on a road to settlement thereafter, and that they intend to do something about that to make it as difficult as possible. And the Home Secretary indicates that that the successful story of migration in Britain has always depended on each wave becoming a part of our wider cultural life and paying back. And she gives the example of her own family coming to the UK. Now, this is not the purpose of this talk, it's not an ad hominem attack on the Home Secretary, but I merely observe that the Home Secretary's family came to the UK without any restrictions on the benefits that they could achieve along the way, ready, early and easy access to settlement, and ready, early and easy access to the acquisition of citizenship, which is not what she's proposing for everyone else. So what we see are a number of things, and the way it cuts mainly is in a number of areas. Firstly, as Sonali has indicated, delaying settlement. Secondly, prohibiting access to welfare benefits. And I am going to spend a little bit of time on this because what's missing from this analysis, and it seems as if the Home Office have written this policy without phoning up their chums in the Department for Work and Pensions or the Ministry for Housing, Communities and Local Government is any understanding of how the social assistance and social security system in this country underpins the labour market and the role that it plays in supporting the labour market, both for people who temporarily, through no fault of their own, fall out of work, and secondly, as a form of in-work benefit. And I'll just highlight how this works at the outset. The wages in this country are set at too low a level for people to pay their accommodation costs, either rent or mortgages, and secondly, to pay for the cost of raising their children. So we have a benefit system which is designed not simply for people who are scroungers or who are out of work, but for people who are in work. And it's integrated. The level of support you receive is integrated from universal credit and the like, is integrated into the amount that you earn. And there's a direct relationship between them. So you lose 55p of universal credit for every pound your earnings go up, for example, until you no longer receive universal credit. But a lot of people continue to receive the housing cost element of universal credit, including help with interest on mortgages, or the childcare element of it, which allows you to claim back money for paying for childcare whilst you go out to work. And so it's not just a question of removing benefits from people who are lawfully able to be employed. It has a direct ability on the ability of the same person doing the same job to be able to pay their way. And it's been integrated very carefully over a number of years. You can't just cut it off like a boil off your foot or something and suggest that the rest of the foot's going to be fine. Everything works together. The second reason manufacturing of point about segregation is this idea about voluntary work, and I'll come on to that, as ways in which you can cut the period of time from your path to settlement. And we've been there before. Sonali touched on the HSMP thing and other policy proposals that have been challenged in the past. But some of you may remember Gordon Brown's government and the earned citizenship proposals, where there was going to be no ILR, you were going to have short-term leave to remain, then this euphemistic period called probationary citizenship, which was more leave to remain, in fact, and then you'd be able to get to British citizenship when you'd be able to get benefits. This is a rebaked or slightly recooked, couple of ingredients taken out, a couple thrown in, policy that we have seen before. It never came into force because of the general election in 2010. And so what we see are a series of policy proposals designed to address the issue that there are divides in society, but we see that these divides are actually being increased by the imposition of prohibition, firstly on in-work benefits for people who are lawfully resident with limited leave to remain. Secondly, postponing the point. If the point of indefinite leave to remain is postponed, then an attempt then to say, well, only when you get indefinite leave will you be able to receive these benefits. And then thirdly, a further proposal, which will require primary legislation potentially, to reform the British Nationality Act so that you end up only being able to get benefits once you've achieved British citizenship. And so those three things will create a parallel society. And what you'll see is sorry, I keep moving the clicker the wrong way. It's very irritating, not least for me. But what you see there are how they're going to do this, because it's very important to understand what no recourse to public funds means in practice. There's going to be a penalty delaying your route to ILR, even where there is no condition restricting you on having no recourse to public funds. The definition of public funds is found in paragraph 6 of the immigration rules. It applies to cash benefits, but also to homelessness assistance if you temporarily suffer from a catastrophe in your life, permanent social housing, so that's part 6 housing in the jargon for those who are familiar with the Housing Act 1996, and also potentially for other benefits in kind, in addition, so not just cash benefits, but benefits in kind like homelessness assistance, but then also those regulated under the Care Act or under the Children Act for the provision of accommodation regulated by Schedule 3 of the 2002 Act. And so I've already touched on the role of cash benefits as in-work benefits to meet housing costs, childcare costs, child costs, what we used to call child tax credit before universal credit came in. But it also bites further. It bites on child benefit, so the fixed amount before you get to the child costs element of universal credit, a universal benefit, and benefits for disabled persons. There's no indication in the Home Office policy guidance of any conversation with the Department for Work and Pensions or the Ministry of Housing and Communities as to how that's going to interact with benefits in kind. Because if you can't get cash benefits and then you fall into some kind of social catastrophe, you'll be going to your local authority for a benefit in kind, for accommodation, for support, and so on. It's completely missing. There's also no indication of any principled relationship whatsoever with the role of contributory benefits. You pay your national insurance, you get contribution-based new JSA, new employment and support allowance. That's not where it's means tested. You've earned it, you've paid for it. How the poor old Home Office decision maker is to decide how long you're going to take on your path to settlement when they have no idea what a contributory benefit is going to be interesting to see. And nothing in the Home Office paper on the interaction with local authority benefits in kind. There's simply no understanding of the role of the benefit system as social insurance for people leading ordinary working lives. There's no understanding of how it interacts with pension system, with contribution-based pension entitlement, with the pension credit element of means-tested benefits. There's no analysis whatsoever of how this is all going to be applied. And because we have quite a complicated system of contribution-based benefits, means-tested benefits, and universal benefits, you need to think about that before you start taking away things from working people. What will this lead to? Well, if you can't afford your accommodation because you don't get housing costs element of universal credit, you're going to have to find cheaper accommodation. You're at greater risk of exploitation. You're going to cluster together with other like-minded people. It's going to create a visible form in the urban fabric of our cities, potentially, of people living in poorer accommodation at risk of exploitation. The same for supplementary employment. If you have only able to earn a certain amount and you can't get the top up that comes from universal credit as an in-work benefit, you might breach supplementary employment rules under the immigration rules, risk employer exploitation. If someone gives you a job, they know you're at risk of that sort of thing. You're creating a situation where you might be in breach of the immigration rules over your conditions of leave. And then the second thing is how this interacts with the hostile environment, because of course employers will be especially the civil penalty regime, breach of conditions, potentially the criminal law. Remember Section 24B of the Immigration Act 1971 on unlawful employment, introduced by the Immigration Act 2016 into the thing, and potentially that can lead to your removal. So you're being watched, you're being set up to fail in this situation because lawfully resident persons require, on occasion, in-work benefits in order to do the same, in the same way that, if you like, those members of the settled population who are British citizens and other people who already have permanent residence require it as well. It's just part of the fabric of working lives. It can't be severed as easily. Then we come on to citizenship. If you want to integrate people, as when the British Nationality Act was a bill in 1980, they thought, if you have ILR and you have a child in the UK, that child will be born a British citizen. That will contribute to integration. You go back and you look at the Hansard from the British Nationality Bill, as it was at the time, and that was the idea. That's why the children of people without time restriction, those with ILR, get British citizen children born in the UK just as the children of British citizens do. If you postpone the moment that you get ILR, you postpone the moment that that child is born British in the UK, you inhibit integration into UK society. Similarly with Section 1.3, if you postpone the date when a child's already born, when their parent gets ILR, you postpone the moment when they're able to apply for registration by entitlement. You also, of course, postpone the moment, of course, when the person who's come to the UK can naturalise. And you've put the primary value on the acquisition of British citizenship. You postpone benefits until that moment. You are delaying the benefits of belonging, psychological benefits, which are examined by Mr. Justice Jay in the PRCBC case that went on to the Supreme Court, but his judgment captures that with the greatest degree of precision as to how it's not simply the social entitlements, but that sense of belonging. If you want to create communities, you better create the legal basis in order for them to subsist. The other thing which is missing is that some people cannot get British citizenship easily because their home state is intolerant of multiple nationality, penalises them in their relations with their home state, their ease to go there, sometimes property rights. There is a good reason why some people don't simply become British citizens, apart from a certain scepticism about its benefits, and that's because it's difficult. It makes their lives difficult in a number of different contexts. So there's no evidence that this package of postponement and of creating barriers to integration by throwing up monuments to segregation will actually address any of these divides. It's likely to create visibly different ways in which people will live their lives. It disregards the role of social protection as an enabler of the labour market. And there's simply no way of measuring this. If you're trying to bring people together through the results of these policies, how on earth are you supposed to see you've achieved it? How are you going to go knock on the doors of people who think, how are you feeling now? It's not a sensible basis for making policy to address the problems in UK society such as they exist. So bear in mind also from a legal perspective that it's going to have, I'm sorry about this typographical error on this page, it's deliberately designed to see if you're reading the slide, but it has, think about the impacts. Families from certain backgrounds, ethnic backgrounds, history of migration, are likely to have people in their households who will be disproportionately impacted by this. So that family, where benefits are often accrued because family members, if you have children in the household and so on, there would be an element for a child, there'd be an element for a parent who's got settled status already or who's British, and then that family will have one parent potentially who can't claim. There'll be differential racial impact, there'll be indirect discrimination, which the state will attempt to justify. Both this is a public sector equality duty issue in the formation of policy, and secondly, of course, discrimination as a private cause of action under the Equality Act will be there. There's also the question of Article 14 and compatibility with the Convention on Human Rights. Now, I dealt with the hubris of this policy before, and now I come on to the nemesis. Commonwealth citizens are entitled to vote. Those with limited leave to remain in this country are enfranchised on the same basis. It's simply not the case that you can appeal to the electoral population of this country. And of course, aliens are, but Commonwealth citizens are. There are large groups of people who will be affected by this policy who simply are as enfranchised as the British citizen that this policy who's feeling their patriotism being tested, who are able to vote on these issues. And there is a political dimension to this. The other thing is that there are other elements of the national interest other than reducing net migration. If the UK wants to attract people to the UK, the way in which economic migrants who come here with lawful leave to remain, leave to enter and remain, think about things is they look at settlement packages, and this is shorthand to use that term, it's not a term of art. They look at how am I going to get in? What's my route to settlement? When can I bring my family members? When have I got my permanent hook? When can I get my citizenship? Will I go to Canada, try for the US, try for the EU? It's still there next door. If you make policy in a vacuum and you have no regard whatsoever for the inbound economic migration policy of your near neighbour with a market of about 400 million people next door, more fool you. Because there are other interests here. Secondly, of course, migration from EU member states to the UK itself. When within the EU, people could still move freely. If you want to attract the so-called brightest and the best from the European Union, it's a funny way to go about it. And that those near neighbours are as much people who the UK immigration policy ought to be thinking about as people from further afield. So both in terms of the EU's continued existence on our shoulder, if you like, but also its own economic migration policies. There's simply no understanding of how people think at all when it comes to attract the kind of people that you want to attract to the UK. So it won't work. It's also railing the pitch for the next government potentially of a different stripe. Once you've got rid of economic policy, once you've done all of these things to make life difficult for people who are coming here to the UK, and it doesn't work, what's left? Potentially somebody can pop up from a different political perspective and say, well, you've tried all of this and people are still here, they are still visibly different, these series of rights restrictions haven't worked. So you've effectively rolled the pitch and cleared the way for an attack on the Human Rights Act. And that's why, and for ECHR withdrawal, because the current government's policy in this area is that if we do all of these things, you will notice and you will be less inclined to withdraw from the ECHR or to restrict the Human Rights Act insofar as it affects migrants. But seeing as these things perpetuate the idea of a two-tier society, they make visible differences, they manufacture segregation, the chances that the people whose feelings are being addressed by this policy thinking, oh, okay then, thanks for that, now I have decided everything is all right, I'm going to think about something else, are zero. And so the reason this policy doesn't work is because it doesn't achieve anything. that it sets out to do. It can't to achieve anything. It manufactures a situation where people continue to be treated as visibly different in practical ways and creates, if you like, a kind of legal dynamo for perpetuating the very problem it seeks to address. So for that reason, when you fill in the consultation, you might want to bear about those things in mind. Thanks very much.
Thank you. Thank you very much, Adrian. I've just been reminded of something that I read by Sundar Katwala in the Eastern Naik. And this isn't what this government is necessarily doing, but the Tory government, I think, have suggested it, that the only people who propose getting rid of lawfully settled persons in recent history is Idi Amin in Uganda. So just be careful what you wish for, obviously. We are coming to the end of our time. I do have a question online. I'm going to take that question first, and then see if anyone else, because it seems to be a broad application. I receive queries from refugees who are due to fly for ILR in April and May next year. Are they likely to be affected by the changes? Yes. Is it worth making an application 3 months early? I mean, the problem is if you either meet the qualifying period or you don't. So I think that is quite a difficult question to answer in terms of applying early, because you still may well be refused but on the other hand, we don't have a start date, so but I don't think I can give any better answer to that at the moment. If there are any questions in the room, and then we'll move on.
Thank you for all the speakers engaging such a nice conference. The question is, I would like to share your thoughts. I want to know all of you that Mr. Berry and Ms. Sonali as well. What will be the prospects for these knee-jerk kind of changes, and down the line, do you see any kind of challenges in by challenging all those rules or proposed legislations in High Court or any appropriate forum?
I mean, well, I think Adrian outlined some potential challenges and compatibility questions. I think those will have to be litigated. I was also thinking about the process arguments under Section 55 in relation to children, which, certainly, is it clear that those have been, that the government have actually considered their rights as a suggestion, but it doesn't deal with some of the points that Adrian has just raised, for example.
Most likely, retrospective enforcement of those regulations will be enforced. Most likely the duration has been increased. When those will be enforced, whether it will be retrospectively enforced, or those challenges are ahead which Home Office has to face eventually.
Yes, I mean, at the moment you can't put restrictions on ILR in terms of access to benefits as a condition of leave, but there's a proposal that if they want, that is a proposal of the government in the consultation, that they might postpone the moment you're entitled to the citizenship stage. That will require primary legislation, and of course there's no bill in Parliament at the moment, as will reforming any changes to the path to naturalisation require amendment to the British Nationality Act. Reform have suggested that if they were leading the government after the election, that they would also try and impose restrictions on people who've already got ILR as well. So the reason I mentioned this shadow of the election was simply not just about the Human Rights Act, but because the idea that there's an end point suggests would require this government to win the general election in 2029. It's very much on everybody's policy agenda to see if ILR, whether it's about to get, if you get, conditions on access to benefits and periods, but potentially it might be retrospective as well. And that's why we need to be concerned about it. But that requires legislation.
Okay, I'm going to take one last question because I'm conscious of the time, and also because people. Thank you. One question, yes?
Yes. So coming back to this 10 years route, what would be the impact of some parents who are on 10 years route because their children are British citizens and they are on 10 years route? So what would be the impact of that? Because people's understanding is after the 10 years route, you can apply for indefinite leave. So these new changes, because I think you did emphasize on that.
Yeah.
What would be the impact?
Well, I mean, the impact is obviously huge, and I think that the best way for us to take those forwards is when we see the new rules in force, then we will have to advise people they may end up having to wait much longer, depending on whether if they're on the 10-year route because they couldn't meet the requirements of the immigration rules, but they have a British citizen child and they will be on a much longer route. That's just going to be the reality of what we're advising people, that they won't, if these proposals come in the way they're currently suggested, they won't acquire their ILR. And then they won't be able to get to their citizenship, and that, and their children may then no longer be children, and they may not be on a route that actually is going to end up as in settlement. They may not be actually on that pathway.
So that means at the end of 10 years, they will have to continue to renew 2.5 years on term service.
Yeah, so there's the cost as well as every other thing. But I'm going to, sorry, we've raised a lot of questions, a lot of issues today, and there's so much food for thought, and it's really important that we are all across the potential proposals. And I certainly wasn't across all of them, so I'm very grateful to my colleagues for bringing those issues to fore people. And so I think that what we should do is have some more conversations for those people who are in the room, and then we will keep looking, and with the consultation response, as Adrian pointed out, really important. But there will be many more seminars like this, either within Garden Court or within our broader immigration law community, because there is a lot of change afoot. So thank you very much for those who came. Thank you very much to those online. Thank you very much.